Good afternoon, everyone. I'm Sean Lyttle with the Law Office of Sean D. Lyttle, where we're committed to lighting your way forward. Welcome to the second episode of 3-Minute Legal Learning, formerly known as 1-Minute Legal Learning. This week, I'm going to discuss child custody issues, but in a very specific and increasingly common situation, which is when the parents aren't married to each other. Specifically, I want to address 3 common misconceptions that often seem to arise in these sorts of cases. One misconception here in Nevada is that the courts will always give primary physical custody to an unwed mother rather than to the father. Another variety of this misconception is that joint or shared physical custody is an unlikely outcome when the parents aren't married to each other. Now, while it is true that Nevada law does establish a presumption for joint physical custody when the parents are married to each other, the standard for all child custody cases is exactly the same, which is the best interest of the child. As I discussed last week, the courts in our state operate under a presumption or a preference that children should have continuing and meaningful relationships with both their parents. And accordingly, even when parents are unmarried, Nevada law still generally assumes that joint physical custody is in the child's best interest. So there's no advantage under the law to an unwed mother in most cases. A second misconception is that an unwed father will have a hard time proving paternity. Establishing paternity in Nevada is actually fairly simple. The easiest way to establish paternity is for the father to be listed as such on the child's birth certificate. If that didn't happen for some reason, but both parents agree about paternity, they can sign a voluntary acknowledgement of paternity form. If all else fails, an unwed father can always petition the courts to order a DNA test, and that petition is routinely granted. The third and final misconception I want to address today is the one that says that unwed parents should wait until there's a problem in their relationship to deal with child custody issues. Nothing could be further from the truth. Child custody fights get ugly, obviously, all the more so if the parents are already mad at each other about a host of other issues. Unwed parents are free to create and sign a formal parenting agreement at any time after the child is born. You can think of that like a prenup or a marital settlement agreement for unwed parents. Basically, it's a way to put in place a plan while things are still good between you, just in case maybe down the road things are not so friendly. And at our office, we actually encourage unwed parents to do that. Child custody is a complex issue, but we're here to help you with all kinds of child custody matters. You can call us at 702-982-6164 if you have specific questions or if you need child custody counsel. Thank you for tuning in to this second episode of 3-Minute Legal Learning. As always, feel free to leave suggestions for future topics in the comments, and we'll see you next time.